Hello, and welcome back to our second annual Just Data Advancing the Innocence Movement Conference. My name is Jamie Henderson, and I am the Director of Data Science and Research at the Innocence Project in New York. We've got a really great segment planned for you. Feel free to drop your comments in the live stream chats. We love hearing from where you all are watching, and give us your questions. This session is really special. It's entitled The Systemic Threat of Racism, Expert Testimonies and Exoneration Timelines. And we are fortunate enough to be joined by a couple of research teams that are really well known in the innocence movement. And so as we are, making our way through this, we'll have two presentations by a period of, Q&A. And we'd like to hear from all of you. Let us know where you are watching, where you're tuning in from, and we'll pass along your questions to our phenomenal researchers. So without further ado, I will pass it on to our very first presentation in this session by Dr. Jeff Kukuka, who joins us from Towson University. Thank you, Dr. Kukuka.
Hi, good morning, everyone. Or afternoon or evening, I suppose, as the case may be. It's nice to see such worldwide representation here. So I am here today to discuss some work that I carried out with my fabulous student, former student now, Lola Famulagun, on how people perceive testimony from medical examiners, particularly testimony pertaining to manner of death. So if we could get my slides pulled up, please. Perfect. Alrighty, so this study was inspired in part by the real-world case of Melissa Lucio. For those who aren't familiar, Melissa Lucio is the first ever Hispanic woman to be sentenced to death in the state of Texas in the United States. In 2007, Melissa's family suffered a tragedy. Her 2-year-old daughter, Mariah, passed away. And for whatever reason, for mostly dubious reasons, Melissa quickly became a suspect as having abused and killed her daughter, despite the fact that all of the medical evidence pointed toward the death being an accident by virtue of the fact that Mariah had fallen down a very steep, very treacherous flight of stairs just 2 days before her fall and suffered a significant head injury. However, and this is what I'm going to be focusing on today, in that case, the medical examiner who conducted Mariah's autopsy determined that the death was indeed a homicide and not an accident, and later testified to that at Melissa's trial. Now, the problem with that testimony is that the medical examiner was exposed to all sort of information about Melissa, including the fact that police had interrogated her for 7 hours overnight in a coercive fashion, during which time she gave an unreliable admission of responsibility for Mariah's death. We now know, as I'll explain in a moment, that knowledge of extraneous information can indeed influence how medical examiners evaluate manner of death from autopsies. Melissa was then convicted of capital murder in 2008. Thankfully, given the increasing concerns over her innocence, she was issued a stay of execution in 2022 and is awaiting a hearing to reevaluate how her case will proceed. As I mentioned a moment ago, my research and that of many others has indicated that medical opinions are not entirely objective. Instead, they entail judgment calls, such that medical opinions can be different depending on examiners' knowledge of extraneous information. Or in other words, two examiners who examine the same body with the same injuries and the same medical history may well reach different opinions of how that person died, depending on other factors that shouldn't have any influence on their opinion whatsoever, such as the person's race. Just a quick sampling of a few studies that have found effects of that nature. First, in 2016, one study had 43 medical experts evaluate the same x-rays of the same accidental childhood fractures, but some of those experts were told that the parents of the child were of low socioeconomic status and were unmarried. That information shouldn't have any influence on their medical opinion of how the injury occurred, but in this study it did. In fact, diagnostic accuracy plummeted to 17% in that study, or another way of saying that is 83% of the time, an accidental childhood injury was misdiagnosed as child abuse by virtue of the fact that the doctor knew that the parents were unmarried and of low SES. In another similar study a few years later, again, they gave a larger sample of medical experts information about a childhood fracture, some of whom also received irrelevant and potentially biasing information about the family. And again, it dramatically increased their perceptions of abuse, even though the injury of itself was exactly the same. I want to focus primarily, though, on a study that we published a few years ago. My colleagues and I wanted to see if these same biases extend even to postmortem judgments. So what we did is we recruited a sample of 133 medical examiners. We gave them a case file to read, and that case file described the unexpected death of a young child. In both versions of the case file that we created, the child was found at home unconscious by a family member, taken to the hospital, at which point she passed away. And we gave the medical examiners information about the child's injuries, customary to what a medical examiner might typically receive. The wrinkle was that in some cases, we told them that the child was white, and the person who found the child unconscious and took them to the hospital was the child's grandmother. For others, we told them that the child was Black and they were brought to the hospital by their mother's boyfriend, thus revealing that their parents were unmarried. Again, that information shouldn't have any influence over the medical examiner's autopsy decision. But what we found is that when the child was Black and brought to the hospital by her mother's boyfriend, even though her injuries and medical history were otherwise the same, people were much more likely to judge the death as a homicide as opposed to an accident. This study sparked a lot of controversy. Coincidentally, this study also came out during the trial of Derek Chauvin for the murder of George Floyd, where issues of bias were also very prevalent. So what ended up ultimately happening is a number of individuals, both within and without of the medical community, chose to write and publish responses to our paper. Many of those responses were simply objecting to our findings, asserting that bias is not, in fact, a concern in autopsy decisions, that there is no such thing as irrelevant information for a medical examiner, and so on. However, some of those responses, including ones that were penned by very prominent medical examiners and the leadership, in fact, of the National Association for Medical Examiners, were very surprisingly candid about what they view as the true function and the true nature of manner of death decisions. What you're seeing on this slide are quotes from some of those papers. So, for example, a group of 80 plus medical examiners said, manner of determination is not a scientific determination. There are no criteria for what makes a manner of death decision correct. Other responses expressed similar sentiments, again, referring to manner of death decisions as non-scientific and questionable. And these medical examiners also clarified that manner of death is not suited for courtroom presentation. Now, the unfortunate reality is manner of death testimony is frequently presented in courtrooms where, as we saw in the case of Melissa Lucio, it can have a great influence over the outcome of those trials and whether, in fact, justice is actually served. So what we wanted to do is get a sense of how non-experts who could potentially serve on a jury understand testimony about manner of death. Again, inspired by Melissa's case, we also wanted to see if their trust in medical testimony might depend on who the person being accused is. In other words, might jurors evaluate the same medical testimony differently depending on the characteristics of the person who's being accused? What we did is we carried out two studies, one with undergraduates and one with users of the website Prolific, to get a broader sense of the US population. Here you can see the demographics of the samples. If you're curious to learn more about the specifics of this study, all of our materials and data are available on the Open Science Framework, which you can access by scanning that QR code. So in this study, we manipulated two variables. A participant in this study first read a description of the trial scenario, in which we manipulated the characteristics of the defendant in this case. Specifically, people read that either a high SES white mother or a low SES Latina mother was being accused of having murdered her daughter, again, very closely modeled after Melissa Lucio's circumstances. So in the situation in blue here, they were told that, excuse me, they were told that the defendant's name was Natalie Martin, that she was an affluent white woman with a college degree, born and raised in Texas, a stay-at-home mom working a fairly white-collar job, and so on. The others were told that the defendant was a Hispanic woman named Natalia Martinez, who dropped out of high school, was an immigrant to the United States, worked a blue-collar job, and rents her home with her boyfriend, thus indicating that she's not married. So again, each participant read either of these scenarios, but all of the other aspects of the trial were the same, including the charges, the arguments, and so on. After they familiarized themselves with the context of the case, we had participants read a transcript of the trial testimony of the medical examiner who performed the autopsy of the defendant's daughter. And in that testimony, we varied whether the medical examiner determined the death to be an accident or to be a homicide. We actually took the verbatim testimony of Dr. Norma Farley from the Melissa Lucio case and adapted it for our purposes so that we could make these materials as realistic as they possibly could be. So here are two excerpts from the testimony. In the top version, the medical examiner opines that the death was an accident, a result of a severe fall that caused a head injury. In the bottom, we see very similar transcript with a few minor but important changes, where the medical expert is now opining that the death was a homicide due to result of the mother having abused her child. So again, the description of all of the injuries and the child's history were identical between the two transcripts. The only thing we changed is how the medical expert interpreted and explained those injuries. So first and foremost, we asked folks to determine, do you think that the defendant in this case is in fact guilty? Did she in fact murder her daughter? Manner of death testimony affected people's guilt perceptions in exactly the way that you would expect it to, right? When the expert opined that the death was a homicide, they were more likely to believe that the defendant was guilty. When the expert opined that the death was an accident, they were more likely to find the defendant not guilty. That sort of goes without saying. What we were more interested in is how people perceived the medical examiner's testimony and whether people would perceive the same testimony differently depending on the characteristics of the defendant. So one question we asked them was to rate how scientific we thought the medical expert's testimony was. Now, remember from a few slides ago, in response to our 2021 publication, the medical examiner community came out and said, manner of death testimony is not scientific and it should not be presented as such. Unfortunately, in our study, the jurors rated it consistently as highly scientific. No matter whether they said accident or homicide, no matter the characteristics of the defendant, the testimony of the medical examiner was perceived as highly scientific, which suggests that jurors do not, in fact, heed medical experts' admonition that their testimony shouldn't be interpreted as such. We also asked our participants to rate how credible the testimony was, and as you might expect, they consistently rated it as highly credible as well. However, we found an interesting difference here, where overall, and in both studies, participants tended to rate the testimony as more credible if the expert ruled the death a homicide as opposed to an accident. Now, these weren't large differences, but they are consistent with the idea that juries do tend to be naturally conviction prone. Or in other words, they don't follow the assumption of innocent until proven guilty nearly as much as we would hope that they would. Finally, we asked them the degree to which they found the expert's testimony convincing. How much were they persuaded by it? Here we found an interesting effect in study one, which was consistent with what we originally expected to find. What happened here is that when the expert testified that the death was an accident, they actually found that accident opinion less convincing if the defendant was a low SES Latina woman compared to when the defendant was a high SES white woman, which is consistent with our hypothesis that the very same testimony could be perceived differently as more or less convincing in this case, as a function of the defendant's characteristics, which really shouldn't have any bearing on the interpretations of the expert's testimony. Now, I want to urge some caution in interpreting this because this finding that you're seeing here did not replicate in study two. We found it in study one, but not in study two. So we're going to have to do some more research to see if this is in fact a reliable phenomenon. So the takeaway messages as I see them are as follows. First, medical examiners believe that their testimony should not be seen as scientific, right? They said as much in response to our paper. However, it is presented in court, and our data show that jurors do in fact perceive it as highly scientific. So there's clearly a disconnect here between what the expert is saying and what the jurors are hearing, and we need to do something to bridge that gap. Secondly, our findings show that jurors bring their own biases into the courtroom. So on the one hand, experts may make biased opinions, then they present those biased opinions in the courtroom, and jurors' biases may actually amplify those biases even further, creating a sort of bias snowball effect that's been discussed in the research literature. Finally, how do we fix this problem? It's clear from this and other research that jurors are not particularly adept at distinguishing between good and bad forensic evidence, right? So we would hope that jurors would provide an effective safeguard, a gatekeeper of sorts, against the negative impact of flawed forensic evidence, which, as we probably know, many of us, has been a common factor across the sorts of DNA exonerations that the Innocence Project has worked on. The better solution is to not only educate fact finders about these issues so they can make more informed decisions, but also reform how autopsies are conducted so that hopefully biased opinions won't be presented in the courtroom in the first place. I thank everyone very much for your time and attention, and I look forward to your questions.
Thank you, Dr. Kakuka, for that wonderful presentation. Elijah Appleson said incredible research. We've got questions coming in for you. And folks are joining us from Ghana, Germany, Albany, and Florida. So thank you for tuning in and continue to send us your questions and your comments. We are now going to pivot to Dr. Virginia Braden, who is going to be presenting some incredible research in Pursuit of Innocence, a study of race and ethnicity, differences in time to exoneration. Very good. Thank you, Dr. Braden.
Good morning from Northern Kentucky, Cincinnati, Ohio area. I'm so delighted to be here and to have the opportunity to discuss my research with you all. I'm truly honored to be a part of this amazing day. The title of my research is In Pursuit of Innocence, a study of race and ethnicity differences in time to exoneration. The aim of this study was to take a look at exoneration data and see if there were differences in how long it took for members of different racial and ethnic groups to become exonerated and to apply a theoretical premise to the results. And as background, we know from current data collected by the National Registry for Exonerations that there are racial and ethnic disparities. For example, data on exoneration shows that Black innocent defendants spend longer times wrongfully in prison before being exonerated than do white or Hispanic innocent defendants. And available data on exonerations of Hispanics tells us that while overall they spend less time wrongfully in prison before being exonerated than Black and white innocent defendants, in the categories of drug crimes, child sex abuse, and sexual assault, it takes longer for Hispanic exonerees to win an exoneration than white innocent defendants. So just by looking at the data that's been collected on exonerations, we can see that there are racial and ethnic disparities. And at the time of this research, there were only a handful of studies that had looked at time to exoneration, and none of them focused on race or ethnicity as the central issue. So the purpose of this study was to contribute to the existing literature, go beyond what had already been done by determining if there were racial and ethnic differences in the length of time to exoneration, and then to contextualize the results by looking through the lens of focal concerns theory. And focal concerns theory originally emerged as a theoretical model to explore gender differences in sentencing, but a later version was expanded to include other social characteristics such as race, ethnicity, and age. And the basic premise of focal concerns theory is that judges and other decision makers are concerned with several key points when making their decisions, and that the social characteristics of the defendant, as well as other extra-legal and legal factors, have an influence on their decision-making process. Focal concerns theory also asserts decision makers utilize heuristics and depend on stereotypes in arriving at their decisions. Hypothesis one for the study was that racial and ethnic differences are present in the length of time to exoneration. And hypothesis two is that the legal components of the cases would be associated with racial and ethnic differences in the length of time to exoneration. Data for this study was obtained from the National Registry of Exonerations. Specifically, it was a subsample of data on 489 exonerations, which occurred from the years 2008 to 2018. And a number of measures were used for the study. They included the number of days to exoneration and whether or not an exoneration took place within a specified number of days. And specifically, that was whether or not the exoneration took place within 1,000 days, which was determined to be the median time to exoneration for the sample. And other measures included extra legal and legal factors associated with focal concerns theory. Extra legal factors were age, and that was the actual age at time of crime commission, as well as the race and ethnicity and biological sex of the exoneree. There were 7 legal factors that were utilized for this study. You may recognize some of them as being contributors to wrongful convictions. First was official misconduct. Second, inadequate legal defense. False or misleading forensic evidence was included as a legal factor, as was mistaken witness identification, perjury or false accusation, and also being convicted of a drug crime or being convicted of a violent offense. And the independent variable was the race and ethnicity of the exoneree. The dependent variable was the time to exoneration. For this study, 5 different models were estimated. The first model consisted of all the data and legal and extra legal measures for a subsample that included only Black and white exonerees. The second model was comprised of all that same data, but for a subsample which included only Hispanic and white exonerees. And the third model was the data for white exonerees. The fourth was the data for Black exonerees. And as you might be able to guess by now, the fifth model consisted of the data for Hispanic exonerees. Data analysis for this study took place in a series of steps. First, descriptive statistics, second, bivariate correlations, and 3 was survival analysis. And survival analysis is a family of techniques designed to model the time it takes for an event to occur when there is a possibility that event will not occur for all in a given sample. This was accomplished using the Kaplan-Meier method and log rank test. And step 4 was logistic regression, which was performed once for each of the 2 comparison groups, and then again for each racial and ethnic group separately. Lastly, the Z-score was applied to see if there were differences in the results. Looking at some of the demographics now, you can see the racial and ethnic breakdown for this sample. 46% were Black, 41% white, 13% were Hispanic. You can also see the gender breakdown. Age at time of crime commission. The youngest was just 13 years old at the time of crime commission. The oldest was 83 years old. And the data analysis for the sample showed that 56% of Black exonerees, 49.5% of white exonerees, and 34% of the Hispanic exonerees were exonerated after the median time of 1,000 days. And to the right there, you can see a few of the legal factors that were utilized in this study, broken down by percentage within race and ethnicity. The results of the Kaplan-Meier analysis of the 2 comparison groups did show that the survival and hazard functions varied by race and ethnicity. So the results, the first group analysis showed that Black exonerees experienced a longer time to exoneration than did white exonerees, and these differences were statistically significant. The results of the second Kaplan-Meier indicated that overall, Hispanic exonerees experienced a shorter time to exoneration than did white exonerees. However, those results were not found to be significant. And next, we have the results of the logistic regression of the 2 groups. So for the Black and white exonerees group, logistic regression showed that race was not a significant factor in time to exoneration for this group. However, as the graphic indicates, having inadequate legal defense as a factor or being convicted of a violent crime was shown to increase the likelihood of having to wait longer than the median time to exoneration. And the results of the analysis of the second group, which was the Hispanic and white exoneree group, did not show ethnicity to be a significant factor in time to exoneration. However, exonerees in this group who were convicted of a violent crime as well as those who had false or misleading forensic evidence as a factor in their case, did have an increased likelihood of being exonerated after the median time to exoneration. For this group, those convicted of a drug crime were less likely to be exonerated after the median time. Next, the next step in the data analysis was the logistic regression for each group individually, and this yielded some predictors of exoneration length. And again, now this is being broken down by race and ethnicity. So for white exonerees, when false or misleading forensic evidence was a factor in their case, they were 2.8 times more likely to spend longer than 1,000 days incarcerated before being exonerated. And white exonerees convicted of a drug crime were 73% less likely to be exonerated after median time to exoneration. And as the graphic indicates, the results of the regression analysis for Black exonerees showed that the legal measure of official misconduct resulted in an exoneree being 2.3 times more likely to be exonerated after 1,000 days. And it was also found that for Black exonerees, having inadequate legal defense as a factor resulted in an exoneree being 2.5 times more likely to have to wait longer than 1,000 days to be exonerated. An examination of the regression analysis for Hispanic exonerees revealed that both legal and non-legal variables had an impact on time to exoneration. In fact, the greatest number of significant predictors was found in the group of Hispanic exonerees when compared to Black or white exonerees. First, it was found that for every 1 unit increase in the age of the exoneree at the time of crime commission, there was a decrease of 7.9% in the likelihood of being exonerated after 1,000 days. So, in other words, Hispanic innocent defendants who were younger at the time of crime commission had a greater likelihood of being exonerated after the median time to exoneration. Next, the results also demonstrated that Hispanic exonerees who had an adequate legal defense as a factor in their wrongful conviction were 115 times more likely to spend longer times incarcerated before being exonerated than Hispanic exonerees who had access to adequate legal defense. Additionally, it was found that violent crime conviction also resulted in a Hispanic exoneree being more likely to spend more than 1,000 days incarcerated before being exonerated, and that was an increase of 42 times more likely. Lastly, the legal variable of false or misleading forensic evidence was also predictive of a longer time to exoneration. Hispanic exonerees with false or misleading forensic evidence in their case were 16 times more likely to have to wait longer than 1,000 days to be exonerated. And next, in order to establish whether those disparities between racial and ethnic groups were statistically significant, the Z-score was applied. And the results showed there were no differences in the impact on time to exoneration rising to the level of significance when comparing the disparities in the focal concerns measures between white and Black exonerees. However, there were several disparities between the Hispanic and white exonerees, which were found to be statistically significant. The results indicated that the impact of being younger at time of crime commission was stronger for Hispanic exonerees than for white exonerees. This resulted in a greater time to exoneration for younger, wrongfully convicted Hispanics than for younger, wrongfully convicted white exonerees. Additionally, the detriment to Hispanic exonerees who had an adequate legal defense in their case was greater than it was for white exonerees who also had this as a factor in their case. And lastly, the impact of being convicted of a violent crime was greater for Hispanic exonerees than it was for white exonerees who had also been convicted of a violent crime. So in summary, in regards to the first hypothesis, the results of the study did demonstrate that racial and ethnic differences do occur in time to exoneration. The results of the study indicated that Black exonerees were more likely to have to wait longer for exonerations than for white and Hispanic exonerees. In regard to the second hypothesis, the results of the study indicated that the legal components of a case are associated with racial and ethnic differences in time to exoneration. Overall, as a group, Hispanics were not shown to spend more time before being exonerated than white or Black exonerees. However, it was demonstrated that certain legal and non-legal variables did result in Hispanics being more likely to experience longer times to exoneration than white exonerees with those same factors present. and it was shown that these differences rose to the level of significance. Lastly, the results indicated greater time to exoneration was associated with several measures which are posited by focal concerns theory to have an impact on outcomes, and it was shown these factors did not impact all races and ethnicities in the same manner. So in conclusion, putting it all together now, these results provide additional evidence of another area in the criminal justice system where racial and ethnic disparities exist. For Black and Hispanic innocent defendants, the travesty of a wrongful conviction is then compounded by the impact of longer time spent incarcerated before being exonerated. In short, the remedy to the injustice of a wrongful conviction is itself applied in a manner that is unjust and that disadvantages wrongfully convicted Black and Hispanic defendants. So some thoughts on what can we do about this. First, empirically based training to address racial and ethnic stereotypes in the justice system should be a requirement. Research findings from social cognitive psychology indicate it is actually possible to reduce unconscious bias and the reliance on stereotypes through education and training. And second, it is suggested that legislation be enacted that would require states to regularly assess racial and ethnic disparities in the justice system, including in the realm of wrongful convictions. And this would be modeled after the Juvenile Justice Delinquency and Prevention Act and would follow those same processes outlined in that act. And third, it is suggested that data collection guidelines for recording ethnicity consistently at all points of the criminal justice system be implemented. And the last thought here is that policies and protocols be enacted across the board that address the significant hurdles non-English speaking defendants face to allow them to fully participate in the legal process. This would include things like vetted translators and access to documents and forms in their own language. And a few suggestions for future research are that researchers investigate the impact of other extra legal factors on time to exoneration. And second, that researchers supplement their quantitative data by interviewing individuals and criminal justice decision makers about exonerations. This would provide much needed context and additional information about the decision-making process that's involved and give added insight into the use of focal concerns theory in this area. And that concludes my presentation. I thank you for your time.
Thank you so much, Dr. Braden. Our audience is loving your research as well. LeapStep, username LeapStep says fabulous research. And Jill Hicks from DC said this is necessary research that we need to further understand inequities in our legal system. And so we've got about 15 minutes here together to have a discussion, and we continue to take questions from our live audience. So please put those in the chat wherever you're watching, and we'll pass those along to our phenomenal researchers. First question that we have is for you, Dr. Kakuka, and it's from Keenan Pace, who is tuning in from New York. I wonder if Dr. Kakuka has a guess or opinion about the effect of police procedurals on jurors' belief in the scientific nature of medical examinations.
That's an excellent question. So it goes without saying that forensic science on TV, right, is prevalent. It's everywhere. And it typically portrays forensic science as infallible. There is some research evidence that watching these shows does in fact create unrealistic expectations about forensic evidence. We see that manifest in research in a number of ways, particularly as soon as a juror steps into the jury box, they come in with a preconceived notion about how accurate forensic science is. And we know that they tend to dramatically overestimate how reliable it is. For me, though, a bigger concern is that a lot of these shows portray forensic science as highly automated, when in fact there's a lot of human judgment involved in those decisions. That's the part that often gets overlooked, that isn't, you don't see that on TV so much. And as we know, humans are only as good as their brains and their decision-making processes are, so humans can indeed make mistakes.
That's very true. Next question is for you, Dr. Braden. Caitlin from Philadelphia wants to know, why is having consistent data collection of ethnicity important? And what is the impact of not having consistent standards for recording ethnicity in the legal system?
So it's incredibly important. Data is how we get a picture of what is happening and what experience different individuals are having in the justice system. And researchers have repeatedly pointed to the striking invisibility of Hispanic data. It's just not collected consistently, sometimes across the same jurisdiction. So we do a terrible job at this. It's like taking a Polaroid that never develops. And the impact of it is that we really don't know what the experience of Hispanics that come into contact with the justice system looks like. So we don't know what's working, what's not. We are not able to get a clear understanding. And of course, that's so critical to reform. There is a TV streaming series. I don't know where it streams. That's Bosch, is the homicide detective. And he's got this line. He says, everybody counts or nobody counts. And we really cannot say we are working for justice for all when we will not do the work it takes to consistently collect data on ethnicity. It is critical and essential to understanding what experience they are having in our justice system and where there might be a need for change, and also what is working.
Excellent. Thank you so much, Dr. Braden. I think that that's absolutely accurate. And that the entire legal system needs a rehaul to think about how we capture descriptions of who people are and allowing folks to self-identify and be as inclusive as possible. Okay, let's see here. This next question I think is pretty important, and it kind of takes us back to our foundations as social scientists. And I would like to pose that to both of you. We have a lot of students watching, young and hopeful scholars, and this is an opportunity for them to interact with you and kind of learn how you got to where you are and why you're interested in this work. And so if you could just kind of walk us through that, I think that would be really helpful for those who are watching. And Dr. Kakuko, we'll start with you. Thanks.
Yeah, absolutely. So honestly, it was just through reading the stories and talking to the people like Christopher, who you heard speak earlier, right? And sort of trying to understand how on earth could this horrible injustice happen and how could we have prevented it? I've gone through a few different paths in my own sort of journey toward where I'm at now. I started actually as an eyewitness researcher, and Jamie, you talked earlier about the importance of eyewitness identification or misidentification in a lot of known wrongful conviction cases. I then shifted gears a bit, became an interrogations and confessions researcher when I was in graduate school. And as we were seeing patterns in these confession cases, where as medical examiners and forensic scientists were being aware of confessions and all of a sudden changing their opinion about the evidence, right? And we saw that time and time again. And around that same time, the National Academy of Sciences in 2009 released a pretty damning report about the current state of the forensic sciences in America, basically saying that the forensic sciences are not nearly as scientific as the name would imply, and that they are subject to human error, and that they are, there's a lot of room for improvement there. So it is a very ripe area for research for any students or young professionals who are listening. This is an area where we desperately need more social scientists, because we're increasingly understanding the human element of forensic science and how the brain can get in the way of an accurate decision. And forensic scientists are increasingly listening to us, and they're saying, okay, what should we be doing differently to prevent these sorts of errors? And they're relying on our input. So if you're looking for an area that's very cutting edge, where we've got our work cut out for us, and you have a chance to make a big impact, this is a great place to get involved.
That's great. Thank you. I really appreciate how you ended that. This is essentially a call to action. Join us in this work. It is incredibly impactful. That's why we have events like today. And so then, Dr. Braden, I would like to give you a chance to answer that question about your journey to become a social scientist and exploring wrongful convictions as well.
Well, thank you, Jamie. I had a personal experience on ramp. I was a victim of a violent crime many, many years ago as a freshman in college, and that launched me into a career of violent crimes investigations and victims advocacy. And I was passionate about representing those, whose voices have been silenced, who are no longer with us. And along the way, I came into contact with the concept of wrongful conviction. And I realized here's a whole nother type of silencing voices. And I do contract work for the Ohio Innocence Project. So for about 12 years now, I'm boots on the ground doing those investigations. And I'm passionate about the data because that tells us what is happening. But I also understand the data as flesh and blood human beings whose lives have been decimated by the impact of wrongful conviction. So I take those cases home with me. I wake up with those cases, and data is the way forward. Research lets us know what is happening, what might potentially solve what is happening. How can we eliminate these things? To me, it's just common sense. Research is absolutely critical to eliminate this. It's simply not acceptable in any way, shape, or form that things continue on the way that they are. And data is how we champion the reform. It's how we gauge the results of the reform. It's how we tweak things. It literally gives us the picture we need to be able to ensure justice for all.
That's excellent, Dr. Braden. You're exactly right. The data tell the story, and we use our skill sets as social scientists to analyze things in a way that we know that these results are not due to chance, that there are real issues. So thank you for that. We have a question from April Moore, and she wants to know, and I think this is for you, Dr. Kakuka, but you're both welcome to respond. Don't experts have a stake in the outcomes too? They are paid for their testimony and want to be go-to experts for the state.
Yeah, that's a very tricky issue. So there is some evidence that experts can be unconsciously biased in favor of whatever side they're working for. And that applies not only to forensic examiners, but also to psychologists like myself, right, who might do evaluations or assessments for the court. So it's important for us to practice what we preach. And when I work as an expert on a case, I know I always take extra precautions, document everything to be sure that I'm doing everything that I can to reduce bias in my own decision making, so that I can't be accused of the very thing that I'm, accusing others of not protecting against sufficiently. I also want to just echo the importance of Dr. Braden's last point about data telling the story, and Jamie, you echoed that point as well. We have a tremendous amount of data from some really talented social scientists and other folks working in this field. That, as Matthew and Christopher were talking about earlier, we can use to shape legislation. And we trust data. We rely on data in so many other aspects of our life, whether it's medicine or something as simple as checking the traffic in the morning, right? We rely on data constantly, and we know that data is helpful. Why not adapt it to this domain as well?
Absolutely. Very true. So our next question is for Dr. Braden, and you touched on this in your presentation, but I think if you could just perhaps go a little bit more in depth. One of our viewers wants to know, what are some of the ways that language barriers impact the Hispanic, Latinx communities who become justice involved?
Research shows that language barriers pose significant hurdles. It impacts their ability to be able to comprehend what's happening in the legal process at all stages. This particular study, my study, illustrated the impact of inadequate legal defense. And there's definitely precedent that says that language barriers impact the ability to be able to access legal services that are, and it prevents Hispanic individuals from being able to communicate in ways, even to authorities, that could be beneficial for them. Not having access to post-conviction materials in their own language. This is completely anecdotal, but I talked about this one time with my intern group, and one of my interns spoke up and said her mother is a divorce attorney, and she was in a court in a case, and it wasn't her client, but the other side that had an interpreter. This was just a divorce, and her mother stopped the proceeding to let the judge know she's not translating anywhere near correctly, and some of the things she's saying is nonsensical. Now, in Kentucky, the interpreters are supposed to be vetted. They're supposed to be that assurance there. I cannot imagine anything more terrifying than being wrongfully convicted, and having no idea what just happened, no way to be able to respond to questions, no way to be able to cooperate with or, offer the information that is needed. So it is a definite problem. Research backs that up. Imagine not being able to get the transcript for your trial post-conviction in Spanish. And imagine you're in court and you have an interpreter, but they're saying things that don't make sense and you have no way to communicate that. So it's an absolutely critical issue.
It really is. And I think that's a very poignant example that you give. And so I just, in closing out, we've got a couple minutes left together in this space. And I just want to ask both of you to respond briefly. You both mentioned, educating folks to try to eliminate implicit, explicit biases in the way that jurors, put such emphasis on expert testimony. And so if you could each just take some short time to maybe expand on what the components of that education might be.
Great question. So with respect to experts, awareness is an obstacle, obviously. Getting them to recognize that bias is an issue that needs to be addressed is important. But at the same time, awareness isn't enough, right? We need concrete procedural changes to protect experts against bias. With respect to lay people, non-experts, fact finders, whatever you want to call them, it's a tricky question because as it stands, we know that lay people give too much weight, put too much trust in forensic evidence. But we also don't want to create the opposite problem, right? What we want to do is develop interventions that allow them to detect when forensic science is good and when forensic science is bad. We don't want to, throw the proverbial baby out with the bathwater, so to speak. So that's kind of what we're working on right now.
And I would respond, in line with my research today that training is so. We have research-based results that show that training and education does work. It reduces the othering. It helps us to connect people as human beings and not see them as, what we visually see or their circumstances, that kind of thing. So I think that is something that is incredibly important that it be followed through. But I also think that it's necessary that we capture how that is working. I mentioned the Juvenile Justice Delinquency and Prevention Act, which requires analysis and identification of points where there are racial and ethnic bias present, developing action plans, getting together diverse groups of people to work on that. I suggest it be connected to funding. The results be published annually for transparency, and that there be some accountability. We have this hot spots, right, in policing, and let's look at hot spots with racial bias in within the whole justice system, but I think especially critical with wrongful convictions and exonerations. And, we have the answers. We do. We need more research to help, solidify and shape things, but we have answers. We can move now on things. We can petition legislation. We have critical insights that are needed to change the landscape of wrongful convictions in this country. We just have to take action and show up.
Thank you both so much. That was really powerful. Thank you, Dr. Kakuka. Thank you, Dr. Braden, for sharing your wisdom and phenomenal research with us today. That is the conclusion of this segment. Next up, we're going to have a phenomenal panel on digital dilemmas that explores, race and technology. So we're going to have a brief break before that panel happens. So go refill your coffees or grab lunch or whatever and come back and join us for this great panel with some really amazing experts. And one little tidbit that I would like to leave with our research audience is something that Dr. Braden mentioned, is to continue to think about how we as social scientists can combat othering, whether that's in our work or in the system. We have the skill set to really contribute to that as well. So thank you so much, and hope to see you at the next session and continue to interact with us in the live chats. Thank you.